Hello everyone, I am Stevi Doran. I am going to discuss traditional contracts, the offer, the acceptance, and the in-between. I do have to apologize, I am battling a cold. I will do my best to not have to take frequent breaks and have a little coughing fit. In the United States, contract law was developed over time through the common law practice. This chapter discusses both traditional contracts and e-contracts. Traditional commerce and electronic commerce are very similar as it involves an exchange of goods. With e-contracts, the exchange of goods is conducted online rather than conventionally or in person. E-commerce has undoubtedly been a cost-effective and time-saving method to traditional contracts, but there's a human element lacking from electronic commerce. This presentation will focus on traditional contracts, which are merely contracts on paper. In addition, I will identify the importance of the definitive language within the terms and conditions of a contract to protect both parties from liability and negligence by utilizing a current event. Anything paper seems old school nowadays, but there is an element of honesty associated with paper versions. Working in supply chain, I am responsible for millions of dollars my company spends annually, and relationship management is a critical element to my department's success. When entering into a large contract, we require hard copy to be submitted in addition to electronic copy. Hard copies may be passed back and forth via electronic interchange such as email, but the final version needs to be a signed hard copy. Fraud or deception in traditional commerce is reasonably less than e-commerce because there is that personal interaction between the parties. Not to indicate that our world is dishonest, but technology allows anyone to alter a document, photo, website, etc. at the click of a button. A signed hard copy version is difficult to deny. It is as silly as it sounds, the indentation on the paper from the signature and the initials where they were pressed quickly validate that it was not altered from the original agreed upon version. It may be old school, but it's also undeniable. Contract is a promise or set of promises for the breach of which the law gives a remedy, or the performance of which the law recognizes as a duty. The core of the contract is that it formalizes an agreement between one or more parties. Contracts are created to provide a means for resolving the conflicts between one another. The identified parties build a legally binding relationship between them that is enforceable by law. A contract is enforceable by law. It is formed between an offeror and an offeree. The offeror being the individual or business making the contractual proposal, whereas the offeree is the individual or company receiving the contractual proposal. A contract has four essential elements: the agreement, consideration, contractual capacity, and legality. A legally enforceable agreement for doing or not doing an act is known as a contract. In absence of these essential elements, an agreement is not legally enforceable. Thus, all contracts are agreements, but all agreements are not contracts. Essentially, where there is a contract, there is an agreement, but without an agreement, there can be no contract. An agreement fundamentally gives birth to a contract. The agreement contains both an offer and an acceptance. An offer is a promise to act or refrain from acting, while is made in exchange in return for a promise. For example, if I employ a contractor to perform work on my house, say painting, a painter, the offerer, would quote the job to me, the offeree, and I have the power to accept or not accept his offer. The power of acceptance is formed when the offerer shows intent to enter into a contract and communicates specific terms to the offeree. The painter is stating that he can paint my room for $400 and complete the task in one day. Upon successful completion, I agree in return to pay him the agreed upon amount. The requirements of an effective offer under the contract law. The offerer must have a serious intention to be bound by the offer. The terms of the offer must be reasonably certain or definitive so that the parties and the court can determine the terms of the contract. And lastly, the offer must be communicated to the offeree. The definition of the terms and conditions are very important. It identifies the parties, the identification of the object or subject matter of the contract, perhaps quantity if appropriate, or the scope of work to be performed. It specifically identifies the goods, the services, the land that we are discussing within the contract. The consideration to be paid or its value, and the time of the payment, delivery, and the performance. The parties to the agreement usually commit to performing some action in exchange for something of value, which in contract language is referred to as consideration. Each the offerer and the offeree of the contract must offer something of value that persuades the other to enter into the agreement. In the above painting example, the value exchange is monetary. The offerer is proposing a service in exchange for money, but the value exchange does not necessarily need to always be currency. To successfully enter into a contract, a person must be considered a legal adult and have the mental capacity to understand what they are agreeing to. A reasonable person who enters into an agreement possesses a complete legal capacity and can be held liable for the task he or she agrees to assume, unless the person is a minor, under the age of 18 or 21, mentally incapacitated, or under the influence of drugs or alcohol. The law assumes that minors are too immature or inexperienced to negotiate equivalent terms with an adult. Therefore, the courts protect them from being held responsible for foolishly entering into a contract of any kind. A person over the age of 18 that enters into a contract but does not understand the nature and the consequences of that contract that he or she has entered into, the law treats this person as lacking mental capacity to form a binding agreement. However, he or she will not be relieved from any contractual obligations until the court lawfully arbitrated the issue after taking evidence concerning the party's mental capacity. Contracts entered into by a person under the influence of alcohol or drugs is voidable at the person's discretion, but only if the other party is aware of that impairment. The last essential element of a contract is legality. The purpose of the contract must accomplish some type of goal, and that goal must be legal and not against public policy. With that being said, I chose a controversial situation and an article titled Levin Harvey Weinstein's Contract Allowed for Sexual Harassment. I do not follow Hollywood gossip, but based on the title, I found it hard to believe that a contract would be written in such a way that it allowed for sexual harassment. But I was kind of shocked at what I found out. This situation overlaps with several other categories, including criminal activity, employment law, international law, and a few other areas of law, but I'm going to specifically speak to the contractual elements of this situation. Harvey Weinstein is a former film producer. He and his brother Bob Weinstein founded the entertainment company Miramax, which produced several very successful independent films. In October of 2017, he was terminated from his company and barred from the Academy of Motion Pictures Arts and Sciences following sexual abuse accusations from numerous actresses. What was very interesting is how the contract was written back in 2015. Weinstein was allowed to be sued over sexual misconduct as long as he paid the restitution and a fine to the Weinstein Company. Access to Weinstein's 2015 employment contract, which states that he may be sued for sexual harassment or other misconduct that results in a settlement or judgment against the Weinstein Company. All he has to do is pay what the company paid out along with a fine, and he is in the clear. In other words, he can violate the company's code of conduct and mistreat people, mainly women. In addition to the settlements, he has to pay the fine, $250,000 for the first offense, $500,000 for the second offense, $750,000 for the third, and $1 million for each additional offense. Weinstein's contract specifically states that he must reimburse the Weinstein Company for settlements and judgments. Based on how this contract is written, Weinstein can be sued over and over again as long as he writes the check, he keeps his employment. Therefore, what is interesting about the verbiage in this contractual agreement is regardless of the alleged misconduct, Harvey Weinstein may have been fired illegally from the Weinstein Company. Since termination was not written as a possibility of this misconduct, just that he had to pay the restitution to the company, he might actually have a case for wrongful termination against the Weinstein Company. The contract has specific language as to when the board of directors can terminate Weinstein. If he is indicted or convicted of a crime, which currently does not apply here, or if he creates fraud against the company, which also does not apply here. There is a provision that Weinstein can be fired for perpetuation of material fraud against the Weinstein Company. The Weinstein board member who negotiated his 2015 contract, Lance Mavrov, commented in an interview that the board was aware that Weinstein previously settled lawsuits brought by various women, but the board assumed that these were consensual affairs. Therefore, and again, these assumptions do not constitute fraud on Weinstein's part. The Weinstein Company had a right to fire Weinstein if he didn't notify the board of directors of any settlements. This would then be considered fraud. But there were no settlements since the contract was signed in 2015. Therefore, the clause does not apply here either. Which leads me to my next topic concerning contracts, definition of terms. Following the offer, a definitive term will determine if there is any type of contractual breach which has occurred, as well as what the appropriate remedy should be to resolve. Although there was specific consequences written as to a dollar value for potential misconduct, there was nothing that specifically stated termination. It was also stated that if Weinstein had committed fraud by not informing the board of directors of any such settlements, then he could also be terminated, but he had a right to mediation, and if that fails, he was also entitled to arbitration. He did not receive any of these options. He was just immediately fired. Contracts are simply enforceable promises. Generally, parties need an agreement and consideration where both parties benefit. The agreement exposes the Weinstein Company's involvement. Based on the ambiguous language, the Weinstein Company promised not to fire Weinstein for sexual wrongdoing as long as he repaid the business the cost of the settlements. Simply put, Weinstein Company board members did not terminate Harvey Weinstein's employment because they found out he was a sexual predator. They fired him because the public found out. Therefore, does Harvey Weinstein have a case for wrongful termination? Perhaps, but as mentioned previously, an essential element to the contractual agreement is legality. The courts will not carry out an agreement that is illegal or contrary to public policy. Sexual harassment is contrary to public policy. According to Margot Cleveland, a professor at the University of Notre Dame College of Business, it is unlikely that Harvey Weinstein will sue his company for wrongful termination. There are two reasons. The court will likely throw out the case since the contractual agreement went against public policy, and second, it's not going to do anything for his career. Harvey could face an array of claims against him, though, such as assault and battery, intentional infliction of emotional distress, and sexual discrimination. The Weinstein Company, as his employer, will also face liability for his misconduct based on the doctrine of respondeat superior. The doctrine holds the employer negligible and liable for torts committed with an agent of the company. A typical employer like yours and mine may avoid liability for an employer's sexual misconduct by noting that it took place outside the scope of their employment and was not foreseeable by the company. But since it directly stated it in his contract, it shows cause that the Weinstein Company undoubtedly knew of Harvey's sexual misconduct. Even though they assumed it was consensual, an assumption does not prove that it was consensual and not unwelcome sexual harassment. There is a positive side to this very unfortunate situation. Lawmakers in several states, including New York, New Jersey, and California, are seeking legislation that would limit the use of both non-disclosure agreements and out-of-court settlements with confidentiality clauses in cases of sexual harassment and assault. Often as employees, we sign non-disclosure agreements, also known as NDAs. I've signed them with my company. I know I've signed them with previous companies. These are common and generally can be a condition of employment or a specific position within your company. NDAs are intended to preserve sensitive corporate information from leaking to the public, but they frequently include language that makes employees feel that they cannot speak out if harassment occurs. Hopefully this legislation can correct this silence. Thank you.